Hello, Professor and everyone. My name is Phearun. Today I'm going to present you about one part of settlement and resolution procedure. It is the conception and practice. In this chapter, we'll cover many approach with theory and practice involved in the development of conflict resolution. It is the content that I will present today. Just move to the number one. What is settlement and resolution procedure? It is the process by which two or more parties reach a peaceful resolution for a conflict or dispute. And all parties may take the different approach or settlement activity to their problem by formal or informal action. And there are many approach that are available for dispute party to choose, like negotiation, mediation, arbitration, or if their case is serious, they can choose judicial decision, because the judicial decision is one approach that we can say it is formal, it's binding. And for the number two, settlement activities, as I mentioned earlier about the settlement activity that dispute party can choose. They can choose negotiation, mediation, arbitration, or judicial decision based on their conflict. So I will move to I will explain you more about each approach that the party, before they choose that approach, they have to know about it. So I will tell you briefly about it. Negotiation, it is a formal discussion between dispute party. That means I can, for example, like party A or party B, that they are trying to reach an agreement or a good solution. And negotiation are reached through discussion made between the party or their representative without an involvement of the third party. We can say between party A or party B. And each party should consult or see the lawyer before the sitting down the matter. Thus, they are well aware of their rights and duty in respect to solve the dispute. And there are some characteristics of negotiation, like each party are voluntaries, and their case is confidential, and it is flexibility for them, but it is informal action. I mean that they just only two party that they agree between party A and party B. And another one approach for the for dispute resolution is mediation. Mediation is an informal dispute also. They run by a trained or professional third party. If we see the negotiation and mediation, negotiation they have only two party A and party B. But in the mediation approach, they have include the third party that we call mediator. And meditation is intended to bring two parties together to clear up misunderstanding and find out a good solution for each party. We can say win-win solution. No decision can be imposed on the party involved, and the dispute party may or may not agree on the negotiation settlement. If one party not satisfied with that solution. And there are some characteristics of meditation also. It's not far different from negotiation. That means each party are voluntary, and that approach is not binding, but it is also confidential. Another thing, the role of mediator is to assist the party in reaching negotiation agreement. Unlike arbitrator, the mediator is not a decision making. Mediator is just a person that to facilitate between dispute party. And another approach, arbitration. Arbitration is a form of dispute resolution. An arbitration hearing may involve the use of an individual arbitrator who is independent third party, and each party agree to choose their arbitrator, the place of arbitration, or the language of proceeding with significant freedom and flexibility. The dispute party hand over their power to decide the dispute to arbitrator. And there are some criteria of the arbitration. We can say it is more expert. That means the arbitrator is more expert than the meditation, because some arbitrators are in field of legal form or in terms of their professional. We can say you can sell the time and cost also if we compare this approach to the judicial decision, as I showed you previously. And it is also private, and it more than negotiation and mediation approach. And another one is a judicial decision. Judicial decision is a form of legal opinion written by a judge or judicial panel in the course of resolving a legal dispute, providing decision reached to resolve the dispute, and usually indicating the fact which led to the dispute and an analyzing of law used to arrive at the decision. Judicial decision, we can say it is binding and it is public, because some case we have to public. That means many people can know about the court decision. If we compare to the cost, it is more expensive, because each party need to hire a professional, we can say to hire a lawyer for them to represent for each party, and it may take more time because we need to process more. Yes, I mentioned I just choose only 4, but they have another more approach that dispute party can choose beside the 4 I show you. So move to the number 3, evaluative decision making. And in the part number 3, I just choose only 2 to tell you how to evaluate for the decision making related to each approach. That I choose only arbitration and judicial decision. I choose the 2 because it is more formal than another 2 like negotiation and mediation. So for arbitration, arbitration begins when 2 parties agree to settle their dispute through arbitration. The dispute party hand over their power to decide the dispute to the arbitrator who are well trained, professional, and have expertise in specific area. For example, in we call like in labor, employee that what I want to use that mean the arbitrator they are expertise in some area like lawyer they are expertise in the conflict of international trade, for example, like that. And arbitration provide the party with significant freedom and flexibility, mean that each party can choose their arbitrator. That means till both parties agree to choose that arbitrator for to solve their case, and also each party can choose the place of arbitration and the language for proceeding. And for judicial decision, in judicial decision making, party in dispute have a little control over not only the proceed but also the outcome. I mean that they cannot choose, they can choose only their lawyer to be a representative for them, and each party cannot choose a judge or jury who deliver a verdict on their case. Court arguments are guided by preceding and legal norm rather than analysis of the value and need of the disputant. The decision by judicial authority are generally binding and enforceable. That means after the court decision, all the party need to obey it. It is enforceable. And for the number 4, collaborative problem solving. Collaborative problem solving involves two different constructs: collaboration and problem solving. Some problem solving tasks are too complex for an individual to work through alone, or the solution will be improved from the joint capacity of a team. People varies in information, expertise, and experience that they can bring to bear in order to jointly solve a particular problem. I mean that the particular problem need the capacity of individual person are different, so they can share their knowledge, they can share their experience that related to that problem, so they can solve it. And number 5, assessing decision making mood. I think this point is important because as there are many approaches for party to choose to solve their conflict, but before they choose one approach for their case, they have some factor that each party need to go through. They mean they need to review first. They need to know, like assessing decision making mood mean a settlement process can end by either judicial decision or arbitration or another approach. And here there are many factors which impact on the selection of dispute resolution method, like cost. Why we say cost is important? Because cost is one of the most critical criteria for organization or for each party when assessing in for dispute resolution method to use for dispute resolution. Yes, it is a fetch the profit share approach outcome. it is include third-party fee, documentation, and this both party should do a cost benefit analysis. Mean that the sometimes the they can, that mean this case they have to spend a lot to hire a lawyer and to processing. That mean we can a total cost for that case, that mean huge it compared to benefit that each party can get from it. And another factor is time. The length of time is money. As we know, time is money. The time delay of dispute resolution will delay the process of work, resulting in extra cost and incur potential penalty points. And one more factor that is important, fairness. Some dispute they might bring to the judicial decision making because they think that and that approach may provide them with more effective fairness for them. Like we say, neutrality and fairness deep heavily on the competent training and integrity of neutral third party or court. So if they choose one approach that each party feel not satisfied with the outcome of that solution, so they no need to choose that, because every approach that they choose they need to spend even those the monies or the time. And another one, confidentiality. Yes, very important. Some problem each party don't want to reveal it to the public because they can affect to their business or to affect to their benefit. So they need to choose one approach, like for negotiation, that only both parties can know about it. So they try to keep their information privately. And another one is outcome. The outcome of the construction dispute is usually related to the cost liability. The party which initiate the dispute feel that the other party owed cost for reasons like a variation of payment, final payment, or the compensation cost due to factors like a delay of work, payment for extension of time, and liquidated damage. That means each party may have to know. Sometimes they can expect what the outcome that they can get from the other party if their case, if they win that case. So it is also important. So that's all for my presentation today, and thank much for your watching this video and your attention. Thank you.